Good morning, everyone.
Morning.
My name is Henry Green, and I will be the presiding judge for our cases set for this morning. Before we get started, let me introduce the other judges are here with me. We have Judge Thomas Malone, and we also have Judge Patrick McInerney. Now, before we get started, I'd like to get the appearances of counsel. Appearing for, and this case is State of Kansas versus Jeremiah Wilton Brown. And I'd like to have who is appearing for Mr. Brown, the appellant.
Yes, good morning, Your Honor. Richard Ney appearing for Jeremiah Brown. We're present, ready for argument.
Thank you. And appearing for the state.
Good morning, Your Honors. Assistant District Attorney Lance Gillette appearing on behalf of the State of Kansas, present and ready for argument.
Mr. Ney, would you like any rebuttal time?
Yes, Your Honor. If I could ask for 3 minutes, please.
Are you ready to proceed with your argument?
I am, Your Honor.
Are we ready to hear it?
I hope so. Please, the court, Richard Ney for the appellant, Jeremiah Brown. Your Honors, let me start with the fact that Mr. Brown was deprived of his right to present a defense in this case, both by the court's actions in refusing a continuance to obtain the expert who had already given opinion on the case, and by his counsel's actions in failing to have that expert available. We would say that this case, as far as the court's action is concerned, is on all fours with this court's opinion in States versus Huntley from 2008. Huntley was a case where the defense asked for continuance in order to obtain an expert on child interviewing techniques. There was no expert had been retained at that time, and no opinion had been given, but counsel had asked for that leeway to have a continuance. The trial court denied it on 2 reasons, and basically the same 2 reasons that Judge Brown denied the continuance here. 1, he had questions about whether he would admit the evidence. 2, the case was scheduled for trial and he didn't want to reschedule it.
He argued that this case had been continued too many times. Is that correct?
That was his statement, but Mr. Falk had gotten onto the case very late. He substituted for prior counsel, and this was Mr. Falk's first request for a continuance. But even saying that, there was no statement given by the court why a later date would not have accommodated all the parties. The state objected to this, but there was nothing, for example, that the witnesses were not going to be available at a later time. It's just, well, it's been set before. Mr. Falk had not had any continuances, however. So we look at those 2 reasons, and then we look at what Huntley says about what this court should look at in resolving this. And when the court looks at this, it has to look at this de novo when a defendant's defense is taken away from him by a failure to grant a continuance, as this court said in Huntley. But the court in Huntley said the possible prejudice to the defendant, and the prejudice was high here. Mr. Falk testified that this cut the legs out from under his defense. He had done numerous intoxication defenses before, but not without an expert. The diligence or lack thereof disclosed in attempting to secure the attendance of the witness. Well, that may be a point for the court, but it also goes to Mr. Falk's ineffectiveness.
Let me interrupt you, counsel. Let me interrupt with a question. Wasn't Dr. Goodman mainly going to testify on involuntary intoxication?
No, if you look at his report and what Mr. Falk testified to at the Van Cleve hearing, he said it was going to go to both voluntary and involuntary intoxication. The state makes that argument as a brief, but in our reply, We point out where Mr. Falk testified and in Dr. Goodman's report that it dealt with both. The client's level of intoxication deprived him of his ability to form requisite intent.
In fact, even Mr. Ney didn't, even the state made an issue that they understood it was supposed to go for voluntary intoxication in their closing argument.
Yes, that's correct. Both were instructed on, but without Dr. Goodman's testimony, as Mr. Falk testified to at the Van Cleve, there was really no way for the jury to understand this. This court, the courts in Kansas.
Didn't Mr. Brown establish that he was incredibly drunk that night?
I don't.
Dr. Goodman have added to the equation.
Well, I think there's a big difference between someone saying I was drunk and an expert testifying what that level of intoxication does. Dr. Goodman is a mental health professional, psychologist. He has a diploma in psychopharmacology. He's certainly someone, and if you read his report, can talk about what the levels of intoxication likely were by doing the extrapolation of the theorems on that. He would have added a great deal for the jury, as Mr. Falk testified to. And in fact, as the courts in Kansas have recognized, experts are something we have routinely in intoxication defenses. It's a pretty weak defense just to go in and say, hey, I was drunk, without someone with credentials saying what that means. We add to all this the court's failure with Mr. Falk's failure in having the witness available. And we cited to the Robinson case, again, that's a Kansas Court of Appeals case, where lack of diligence by a defense counsel in obtaining an expert, in that case it was an arson expert, not trying to contact that expert until 2 weeks before trial. Trial Judge Wilson, who's now Supreme Court Justice Wilson, found that to be ineffective, and this court agreed with her conclusions. Added to the problems, if you will, of not granting this continuance to get this critical information, then we have what the state did at closing argument. And I'd like to turn to that, the prosecutorial error question. The prosecutor in this case, first of all, told the jury they could skip, those were her word, that was her word, skip consideration of the lesser included offense, and voluntary intoxication as well. After quoting the voluntary intoxication instruction, she argued as follows: all right, you do not have to do this. You do not have to consider this, okay? It is there, it is in there, but you don't have to do it. This is where the rubber meets the road, folks, because essentially it's a may. It is permissive within the law. It's not a shall, like you have to consider it. You can skip it if you want, but it isn't there. This is a prosecutor not arguing, well, the evidence isn't there for this defense, voluntary intoxication. She is saying you can just ignore the instruction. And we can get all the sort of interpretations by the state of what skip means, but it's clear what it means. If I skipped this argument today, I wouldn't be here. It is not something that is saying the jury, well, there isn't evidence for it. She is saying twice, you do not have to consider it. Skip it. That is a severe error on the part of the prosecutor. And arguments of this sort, we quoted McCorkindale from the Supreme Court, have not been seen favorably. Add to that, she then says that the defense, the intoxication defense, is, quote, a big fat excuse and brushing what the defendant did under the rug, quote, under the rug. That's also prosecutorial error. You can't diminish a defense. You can argue against it, certainly, but you can't say it's a, quote, big fat excuse. The law doesn't recognize big fat excuses as defenses. They recognize defenses. And then she argues to the jury that really the hardest part of the case was when the judge would decide, quote, what happens next. That the judge would have, quote, all the information when it's time to decide what happens next and trust the judge to figure that out. Well, that's an argument, right under Chandler, minimizing the jury's responsibility for deciding the case. It dilutes their role. And case after case in Kansas, and we cited them in our briefing, argue that is, or say that is not something the state can argue. Those three examples, or those three instances of prosecutorial error, are extreme in this case, especially the first, which is telling them to skip a defense. We raised as part of our Van Cleve that Mr. Falk didn't object to those, but frankly, we could argue that and the continuance denial by the judge without attention to an objection. The final issue I'd like to argue to the court this morning and submit the rest of our brief on its own merits is the 455D issue. The state put in evidence under 455D of a prior battery. 455D allows evidence of sexual misconduct, can be considered as propensity evidence. We've modeled that after the federal code. This was not an act of sexual misconduct. It was a battery. Now, the state went behind that, but behind the actual charge, to argue that this was sexual. In fact, referred to it, both the state's witnesses and the prosecutor, as a sexual battery. Mr. Brown was never charged with sexual battery. He was charged with simple battery. He was never convicted of sexual battery. He was only convicted of battery. To allow that now, for the state to be allowed to go behind that conviction, elevate it to a sexual offense, and put it in for propensity evidence, flies in the face of the categorical approach. I don't think if he had pled to a sexual battery, the defense would not have been allowed to go in and say, oh, it was just a battery, if you look at the facts. We have to look at the issue of conviction here when you look at the statute, because it says act or offense of sexual misconduct. Well, that's not was neither charged that way or pled that way. And of course, that was extremely prejudicial to the defendant. I think I'm out of time on my initial argument.
Mr. Nay, I do have a question.
Certainly.
I'd like for you to touch a little bit on the pre-Miranda statements. You said definitely you had problem with that as far as the attorney not trying to suppress or deal with that. And please address that for me.
Certainly. What we argued was Mr. Brown was arrested at his house. He was asked to come out, ordered out, if you want to say it that way. They had no warrant. So number one, we submit that the arrest was illegal when they took him into custody, which tainted other matters. But then they questioned him without Miranda. It's a cute little device to say, you know why we're here, don't you? To get someone to talk. That clearly there should have been a motion to suppress on that. That is interrogation. It is questioning. There's no question he was in custody. And again, we say the custody was illegal. because he's arrested without a warrant. But beyond that, when the police do this routine of, you know why we're here, and to say that is not questioning, I'm at a loss of how that is not a question that is designed to elicit an answer that might be incriminating. And so Miranda was required there. And as we pointed out, the defense counsel, who was Mr. Homey at the time, did not file a motion to suppress, nor did Mr. Falk when he later got on the case.
I'm confused. I thought there was a motion to suppress, which was denied. I guess I'm wrong.
Right, but not on those grounds. I'm sorry. I think that's correct, Your Honor. I'll look at that and give you a clear answer.
It's not that significant.
I'll give you a clear answer in rebuttal, but that issue was never the whole post, that was interrogation was not raised.
Thank you, Mr. Ney. Mr. Gillette.
Good morning, Your Honors, and may it please the court. I'm going to try to address the issues in the same order that my friend on the other side has, and I'll also hopefully answer any questions that this court has as we proceed. Regarding the denial of the continuance and Dr. Goodman, I think that is probably the primary issue that the defendant continues to advocate for here. The problem that the defendant there are a number of problems that the defendant runs into when we're talking about this issue. And primarily, it's that he was not in any way denied his right to present a voluntary intoxication defense. He, in fact, submitted numerous witnesses who testified as to his level of intoxication. The victim also, in this case, acknowledged a high level of intoxication. The jury was instructed on voluntary intoxication, and they rejected that defense. I want to be very clear about what Dr. Goodman was all about in this case, and that requires a very detailed reading of his report. We can gloss over it as the defendant would have this court do and try to make assumptions and logical leaps to conclude that Dr. Goodman was in some way going to try to bolster a voluntary intoxication defense. But that is simply not borne out in the record. It is certainly not borne out in Dr. Goodman's report. I would note that there's one short paragraph in Dr. Goodman's report that basically is a summation of his conclusion. There are two sentences in there that follow his conclusion that the defendant suffered from involuntary intoxication that touch on whether or not the defendant was able to form the culpable mental state to commit these offenses. However, he then immediately follows that up with the statement, he does not have a criminal mind when sober, but when under the influence of substances can act out irrationally and or impulsively. This is not medical evidence. This is knowledge that any common juror can have in the state of Kansas, including the victim in this case, who had never drank alcohol, but freely recognized that the defendant's behavior was out of the ordinary that she saw for him. Dr. Goodman, with all due respect, would never pass a Daubert analysis in this case. I understand, and I also—
Excuse me, then the state agreed that some of his testimony would have probably passed the Daubert test to get it to be admitted into evidence?
I think that what Your Honor is referring to is a statement by our prosecutor during the Van Cleve hearing, and we did
Correct.
and we didn't explicitly concede that there was anything in specific that would have come in. We acknowledged that there may have been some things that might have been able to come in. What those were, I don't know. And I'm obviously, and this court is obviously not bound by what the representation was made during argument at a Van Cleve hearing. The simple reality is that, yeah, there may have been a few things he said, like statements that the victim or that the defendant reported to him. Those may have been admissible. The fact that the defendant, he thought that the defendant had drank, that may have been admissible. Some of the timeline evidence may have been admissible, but his conclusion would not have been admissible.
Don't you think this case is very close to Hunley, which the defense is talking about? Why it was important to be able to have an expert to testify about that. And I like to say that Dr. Goodman, he was going to estimate that the defendant had a really high BAC based upon what the defendant had been drinking that day and his actions. In fact, when you need an expert, that wouldn't be common knowledge for a jury to know someone's BAC based upon what they were doing, their actions and so forth, where Dr. Goodman possibly was going to be able to testify to that?
I think I'm going to start where you ended, Your Honor, and that is possibly. Because while the defense put that forward as a possibility, and obviously Mr. Falk advocated for that possibility, Dr. Goodman did not advocate for that possibility. There's absolutely nothing in his report that would support his ability to conduct any kind of retrograde analysis or estimation of the defendant's blood alcohol content. And this is why Dr. Goodman would never have passed Daubert. I think you make the point being that when you look at his report, he reviewed no evidence from this case. He took defendant's statement as gold and tried to go from there to help the defense. He had the evidence from this case, and he appears to have either deliberately ignored it or he considered it and deliberately omitted it from his report because it was contrary to his conclusion. So no.
Isn't this a real problem with this case? We didn't have a Daubert hearing. I mean, it would really have helped out if we had had a Daubert hearing and the trial court have made the necessary findings, and we just don't have it here. Isn't that a problem for the state?
I'd say two things to that. First, as far as at the time of the continuance hearing, I don't think that it mattered. The proffer was made. The proffer was sufficient for the court to review this evidence and determine whether or not it would have been admissible. The second thing that I would say is that the district court recognized that exact same thing at the Van Cleve hearing and determined explicitly that Dr. Goodman would not have been allowed to testify. This is the same judge reviewing the same evidence, and plus, and that's the failure here, is that the district court judge was reviewing the same evidence. Mr. Ney could have presented Dr. Goodman at the Van Cleve hearing, and he can make a lot of claims, but if he was going to try to rely on Dr. Goodman, it was incumbent upon him to present Dr. Goodman's testimony to demonstrate how it would have been relevant, how he could have possibly passed this Daubert test. So no, I don't think that the lack of a Daubert hearing matters. The district court said as much. The state concurs. If there was one to have been had, it was incumbent upon defendant to do so. He did not. And this court can't infer from that any kind of error here. As far as Huntley, just briefly to touch on the matter, I'm going to try to take a peek at my time, about halfway. Okay. So as far as Huntley, no, this case is not like Huntley. We're not talking about expert analysis here. Again, Dr. Goodman is not qualified, or at least he certainly doesn't express in any way how he was qualified to conduct the kind of analysis about BAC that the court was asking about. The second thing I'd point out there is I don't know that BAC necessarily matters, and that's part of Dr. Goodman's failure as well in not examining the evidence of this case. A highly functioning alcoholic may go from day to day with an extremely high BAC, even potentially within the range that Dr. Goodman supposedly, based on Falk's argument, would have extrapolated to. They can function perfectly fine. That doesn't mean anything. What matters is what the witnesses saw in this case, the witnesses that saw it at the time. Dr. Goodman was not crucial to the defense. I think it's very misleading for anyone to assert that Dr. Goodman was there to support both It's clear he was there for an involuntary intoxication defense. Falk acknowledged as much. He said that it was not critical to his voluntary intoxication defense. There is no possible prejudice under the Huntley analysis. As far as Falk's diligence, he was. Why Dr. Goodman flaked out at the last second is a question for Dr. Goodman, but again, we don't have an answer because the defendant did not call him as a witness. As for the materiality and importance, there's none. What we're talking about here is, again, is an involuntary intoxication defense, which is invalid as a matter of law in Kansas, and I cite that in my brief. The probability of his appearance at a later date, maybe he would have, maybe he wouldn't. Maybe he would have scheduled himself again. Again, we simply don't know beyond Falk's statement at the request for continuance. So I don't think this is like Huntley. We're not talking about the same kind of thing here. Judge Green, I think you had mentioned closing argument in one question to opposing counsel this morning. I think that I've addressed that, but I did note that there was one misstatement by our prosecutor. She does say this. She does say the phrase involuntary intoxication at record volume 6, page 28, one time. But that obviously was not something that was instructed to the jury. It wasn't talked about, it wasn't argued.
Counsel, why don't you shift over to prosecutorial error and try to defend that?
Sure. I think that what's important here is to take these comments in context. And in the greater context, the prosecutor was not telling the jury to simply skip the consideration of a lesser included offense. Her arguments were basically telling the jury, this is what the evidence shows, and it's more than this lesser. That's the first instance of prosecutorial misconduct. And the second one, the prosecutor does not flatly tell the jury that they don't have to consider voluntary intoxication. I put in my brief her full block quoted statement, which is several paragraphs long, of which the defendant isolated what looks like a few sentences. She begins by referring the jury to their instructions. This is where the slip, so she says involuntary and then corrects to voluntary intoxication occurs. May is the big fat word here. It may be a defense to the charges. And then she continues discussing the evidence. She tells the jury they don't have to do this. Her statement that they don't have to consider it is followed by the simple fact that she's directing them to the evidence. Do you buy this? That he's so hammered he doesn't know what he's doing? Do you really think that's the case? Or do you think or do you think that that's simply an excuse? This is a tie to the evidence. This is the defense that he is elected to run, and it directed the jury to consider the evidence of his level of intoxication. The state does not feel that this was error. As for the, let's see. I don't believe that the prosecutor was trying to denigrate the defense. Again, I think that we can look at this all in context, and we understand that the prosecutor, while using colorful language, was directing the jury to consider the evidence, follow their instructions. Even assuming error here, there's no harm. The evidence in this case was absolutely overwhelming that the defendant was guilty of aggravated burglary and I think aggravated sexual battery for breaking in and touching this woman.
Haven't the Supreme Court recently said, for example, in Sherman and some other cases after that, that these improper type of arguments are no longer going to be saying that they're okay, that you have to watch these kind of arguments if you do make them. And in fact, when the prosecutor is saying this was a big fat excuse or brush what he did under the rug, isn't that the type of argument that kind of inflames the passion of the jury, or it can be problematic?
I think that it can be problematic, but when you tie it to the evidence, it's not. And that's what the prosecutor was trying to do here. It was part of a rhetorical question, asking the jury to evaluate the defendant's claim of intoxication. And that's proper argument. The counterpoint, the additional point there is that even if there were some something wrong with that statement, this court still has to consider any prejudice, the potential prejudice. And again, there's none. There was none here. Nothing that the prosecutor said or did during closing argument was going to change the outcome of this case. The evidence itself resulted in the outcome of this case. I can briefly touch on, if there are no other questions on prosecutorial error, I would stand on my brief for the remaining arguments on that matter. And I briefly touch on the battery issue, the 6455D. Now that statute is clear. It allows for the admission of evidence of the defendant's commission of another act or offense of sexual misconduct. That's what we did. We presented the testimony from the victim and the officer at the El Dorado incident, why the prosecutor charged battery for a defendant who gets drunk, comes up from behind a woman, a stranger at a music festival, and roughly grabs her breasts, leaving her with bruises. Why that's not a sexual battery, that's a question that only the prosecutor in Butler County can answer. The simple fact of the matter was, this was an act of sexual misconduct. The conviction itself, the offense being battery, bolstered that fact. And we were able to demonstrate successfully and clearly just how this all happened. So there was not a violation of 6455D here. I see note that I'm not seeing any other questions on that topic. I guess that leaves me with I believe it was issues 8 and 9. Judge Green, I think you had a question about those. The arrest and suppression of defendant's statements.
Correct.
I'll briefly touch on that as well. To be quite frank, the defendant is misconstruing the record here as far as the legality or illegality of the arrest. The evidence speaks for itself. And the evidence is articulated in my brief. Neither Attorney Haney or Attorney Falk saw any issue that would have merited a suppression argument regarding the arrest of the defendant here. He was not ordered out of his house. Police just showed up. His wife went and got him. He came out on the porch willingly and then started stepping off of the porch willingly towards the officers. There was no basis to suppress the arrest here. And any argument to try to expand Jardines, which was a search occurring on a porch, to the area of an arrest of a person in a public place, including a porch, there's no basis to make that kind of jump. There's no basis in law, and it certainly would be run contrary to both United States Supreme Court and Kansas Supreme Court law, as I cite in my brief. Regarding the statements, and this is the admission of the statements, and this is perhaps a little bit of confusion on my part too. I've thought that there was some discussion about the suppression of these statements, and the district court found that they were going to be admitted. I don't think that the officers questioning here, or the statements here, was questioning they were statements. They also followed directly on the heels of the officers explicitly telling the defendant why they were there. They were there about an incident that had occurred the night before. And as I note in my brief, their statements are about, I assume you know why we're here, are just as easily attributable, if not more so, to the simple fact that the defendant was completely compliant and cooperated throughout the entire arrest procedure and process. I welcome any other questions from this court on any of the issues.
Oh, didn't a custodial interrogation?
Jackson v. Deno hearing. I probably caused some confusion by referring to suppression hearing. I think there was a Jackson v. Deno hearing on it.
Yes, thank you. Correct. That does refresh my memory. Yes, and the court determined that those statements were going to be admissible. Sorry, Judge.
Okay. Thank you. Mr. Ney, you have your full rebuttal, and I'll let the state go over a little bit, and you can have a little extra time too.
Your mic's not on, Mr. Ney.
I knew I would do this. Judge Rosen did it himself in a hearing I just had. So I'm in good company. Judge Malone, in addressing what you were saying, yes, there was a Jackson versus Deno. The court ruled that this was not interrogation. We do disagree with the state. What Sergeant Becker said to the defendant was, "Do you know why we are here?" ? And which the defendant replied, "Yes." And then he went on, "Did you expect to see us?" But that's questioning. We cited, while there was not a Kansas case directly on point, there's a Wisconsin case and a Kentucky case, which both say that sort of statement, "You know why we're here," is interrogation, and this was custodial interrogation. And that was raised in issue 9 of our brief, that the court erred in its ruling on the Jackson versus Deno. Turning to what the state is arguing, as far as whether this was voluntary intoxication or not, or designed to go to that, if you look at the motion for continuance, which is in the record at approximately volume 1, 120, 121, Mr. Falk is saying that they were critical to putting on both a voluntary and involuntary intoxication defense. And as the court noted before, when the prosecutor is arguing against the motion for continuance, she says, well, Dr. Goodman's going to say, yep, Brown was really drunk, probably wouldn't form specific intent. She knew this was going to voluntary intoxication. So that just, I'm afraid, doesn't hold water. Everyone knew both was being submitted, and the instructions on both were being submitted. Why Mr. Falk would have Dr. Goodman testified only involuntary intoxication as opposed to voluntary is beyond me. State also has argued in his brief, and here again today, that Goodman had no information about the case. Well, that's untrue. If you look at the record, volume 9, Falk is telling the court what Dr. Goodman had. He says that he sent Goodman all the police reports in the case, quote, so he would be aware of what the government was alleging. Falk also sent him the anticipated testimony of the 3 defense witnesses who was with the defendant. That's all the record, again, volume 9, page 7. So he did provide all this information to Dr. Goodman. And finally, when the state is arguing Dr. Goodman had to be called, otherwise we wouldn't know what he was saying, we look at the Huntley case, there was no expert there to consider at all, let alone the kind of extensive report that Dr. Goodman had. And the court there, which Judge Green, you know Huntley better than I do, and I'm sure since you were on the panel, there wasn't a requirement that an expert then be called to see what they would say. But we want to point out, just in closing here, when we moved for the Van Cleve hearing, the state made the following written argument to this court. Quote, here there is no question that trial counsel contacted an expert witness with respect to defendant's proposed voluntary intoxication defense. Voluntary intoxication defense. So they acknowledged it in the Van Cleve motion, or their reply to the Van Cleve request. There is no question that appellant's trial counsel presented a voluntary intoxication defense. The real question here is whether the district court abused its discretion in refusing to grant trial counsel's motion for continuance. The impact of that decision can be easily measured on direct appeal by balancing the contents of Dr. Goodman's expert report against the facts of the case that otherwise indicated that appellant could form the requisite intent despite the voluntary ingestion of alcohol. So in their response, which is part of the record in this case, to our motion for Van Cleve, they acknowledged 1, it was towards voluntary intoxication, and 2, the Dr. Goodman report itself was sufficient for the court to make the determination about the continuance. The state doesn't want to be bound by what the state says, because it was Mr. Loudon, as the court pointed out at the Van Cleve hearing, who said to the court, I don't know that we would have challenged everything about Dr. Goodman's testimony, but we do feel like he overstepped his bounds in reaching the ultimate conclusion in the case. That was the statement of the state. At the Van Cleve hearing, the state never said he would never have been allowed to testify. And case after case in Kansas, whether the state likes it or not, has allowed expert testimony in intoxication cases. Falk himself testified he'd used it a dozen times when I asked him at the Van Cleve. That is what I have, Your Honors. If there are any other questions, I'd be happy to answer them. If not, we submit our issues.
I see no other questions, and I appreciate both the arguments of the defense and the state. And this hearing will be adjourned. Thank you.
Thank you, Your Honor.